Now the time is 10 o'clock. Exactly, we are resuming the session, and today's resource person is Dr. Anbu Aarumugam, and she's from Chennai, our own staff member, working in Presidency College in the Department of Public Administration. I am welcoming all my delegates and participants. I am so happy every day I can able to meet my colleague Dr. J. Subramanian, Dr. V.P. Tiwari, and Dr. Jayalakshmi, Mukesh, Ramesh, and others, Komal, Anjum Shaikh, Anand, and Kamali, and to mention few names, Kiran Rupa and Vanmadi, Sanju Sarkar, and all my close friends through the webinar. And to few words about our resource person, Dr. Anbu Aarumugam. He's a very young and dynamic teacher, sincere scholar, dedicated teacher, I should say. And she will satisfy every one of the classroom. And she go to the class with a full preparation. And in many occasions, I have seen her social commitments through kind of social services to the student community. Even during COVID-19 pandemic period, Madam is sharing valuable information from Chennai. And every day I get the information through WhatsApp. And to mention few academic accomplishments of Dr. Anbu Aarumugam, she is a fellow of American Society for Public Administration, one of the very pioneer, a very, very prestigious institute in US. And Madam conducted an international workshop for the young teachers and dynamic research scholars some 2 years before in Chennai. And I was also invited as a senior scholar for the meeting. I'm thankful to the madam, and we got an opportunity to interact scholars from US, Africa, and European continent, especially. Still, I can able to maintain my academic relations with my good friends of American Society for Public Administration. And I'm sure that definitely this session is going to be extremely useful. 100% I'm sure, because she has prepared all the material, PowerPoints already, and she has sent the PowerPoint to the Department of Political Science once again. And power facility is not available, power interruption in our campus. We are sitting without fan, without lighting, and with the help of our laptop and power backup, we are conducting the session. And I should be thankful to the HOD, Dr. C. Subramanian, and my technical team, my colleague, Dr. S. Balamurugan. So though I am sitting before you, so they are the people, really they are helping the department in conducting the program very, very successfully without any much interruption. So I should thank the research scholar Narmada, Ms. Narmada. Certainly in the last day, they all will come to the studio and they will also interact with you and they will show their face also. It is, you have to appreciate the young students. They are really more than 30, 40 hours they have been working with the department. So now I request Dr. Anbu Aarumugam, madam. Now the session is over to you, madam. Please, you can go up to 30 minutes. And again, as usual, we are going to end the first session. And kindly relog with the same user ID password. And certainly, we are going to have a very good and fruitful discussions. Please raise your hands. And now over to Dr. Anbu Aarumugam. Madam, now it's time for you.
Thank you, sir. Thank you very much, sir, for your introduction and words of motivation. A very good morning to all the faculty members, practitioners, academicians, students, and those who have joined this course and have continuously participated every day. It's very motivating for all of us teachers also to see such bright faces in the morning and afternoon, especially in these times. It keeps us also going and keeps us in touch with the academic world, which we miss physically during this time. So thank you for your participation and active interaction in all the sessions of this very prestigious course, which is conducted by our university. I thank the head of the department, Dr. C. Subramanian, and my senior professor, Dr. Shaktivel sir, and the technical team, especially Dr. S. Balamurugan, all the others who have helped us in conducting the sessions very smoothly, in helping us prepare every day just before we log in and checking out the facilities we have and giving us good feedback. I thank them all. for this wonderful opportunity. So students and fellow academicians, today we will be discussing a very interesting fundamental right, which is of course non-existent. It is no more a fundamental right. It is a constitutional right, the right to property. Just a few words before we go to the PowerPoint. The right to property is one of the most highly debated, highly controversial fundamental right as it was, and also after it became a constitutional right also, it is one of the most contentious issue which pertains to property. If you remove the word right, all you have left is property. Property is one of the most important aspects in the world that, in the civilized world that we are living in today. It could be a physical property, attachment, inherited property, property that is bought by an individual. But when it comes to property, the most important point that we should remember before we go to the finer aspects of the lecture is any property can be taken over by the government or the ruling standpoint. Now, this is the basic platform in which we have to understand and try to understand the various facets of this particular right. This was why it eventually ended up becoming a constitutional right from a fundamental right. Otherwise, it would have continued to be a fundamental right. But the story of how it became a fundamental right is even more controversial. And why there were so many laws, even we are in 2020 now. It all started way back in 1894. So that's a very long way, before. Even in 2020, there is highly debated, every state, every high court, even in the Supreme Court, there are many cases pertaining to the property rights of individuals. So with this understanding, let's go to the PowerPoint and let's try to understand the finer aspects before the Constitution, during the formation of the Constitution, and after the post 1978 period. So what is happening with regard to this right to property? Why in the course of fundamental rights, why are we studying something which is not at all a fundamental right? That should be your primary question before you actually listen to the lecture. But it is so important and relevant even now. That is why we are actually discussing this particular topic today. So without any further delay, let me take you to the PowerPoint so that we can have a visual that to understand and relate to the idea of right to property. Shall we? I'm going to share my screen today. Just bear with me. I hope you can all see the screen. Please have a look at this particular slide. I would like all of you to mildly go through this particular slide. This is the current position of right to property as far as legislation is concerned. We cannot merely just study about right to property in a very methodical manner, understand the amendments. That is not just enough. It was inserted in the Constitution as a fundamental right. It was then moved to a constitutional right. Definitely, that is the basic idea of the lecture. But what happens on the legislative side? As a practitioner and a follower of this particular subject in Indian polity, we also need to understand that the executive, the legislature, and the judiciary travel together. Of course, there are struggles. They try to overpower each other and all those things. This particular right, fundamental right, is a classic case of the struggles between the executive the legislature and the judiciary. Now, who won? We do not know. The fight is still going on. Even in 2020, there is still a struggle in interpreting the property rights of an individual. That is where this whole idea of right to property itself was born. The preamble of our constitution states that India will work towards providing social, economic, and political justice to its citizens. Now, if in other words, the growth must be there in agricultural sector, industrial sector, and services also. For example, to provide economic justice to the population at large, there needs to be economic growth, which means growth of three sectors: primary sector, secondary sector, and tertiary sector. This we are all aware. Now, the Indian government justifies that for the tertiary sector, which does not demand too much land, but for the primary and secondary sector, land acquisition, land propositions should not be a hindrance or an obstacle to the development of the country. Therefore, public interest may require land for housing projects, removal of slums, land for foreign consulates, settlement of government employees, land for agrarian reforms, technical education, industrial labor. Why do land, government require land is a question that may come in some of your minds. We cannot simply say development. Development can be broken into these kind of finer aspects. Now, again, I would like you to keep looking at the slide. Try to understand the three legislatures. The main, the birthplace of right to property as a fundamental right stems from the Land Acquisition Act of 1894. The very basic provisions of the Land Acquisition Act are given there. And of course, the 2013 Act, which replaced or amended the 1894 Act. What are the provisions there? Just kindly understand that before we slowly ease into the lecture, because so that we can get a holistic understanding of right to property, not only as a fundamental right, but how it impacts India as a country, as a developmental democracy, and also the individual right to property. This will be my primary focus in the lecture. To better understand the right to property as a fundamental right and why it was moved as a constitutional right, we first need to look at the background and the important events and amendments that have led to this section of Part 3 of Indian Constitution to the current state. And there are also some interesting exceptions, restrictions. For example, the property can be acquisitionized for the general welfare of the public or the protection of the interest of scheduled tribes. What is the pre-constitutional position of the right to property? This is very important. The legal and the constitutional framework of the right to property in India has often led to a debate between the government and the courts as to the legality and the illegality of such acquisition. Legislature has made it a question of the manner of exercise of legal power. So it's a very beautifully framed sentence. So it's again showcases the fight for supremacy or dominion between the three organs of the government. The original concept of land acquisition actually emerged from the colonial legislation, which is known as the Land Acquisition Act of 1894. This particular act actually enabled the government to expropriate huge tracts of land on behalf of private industries under the garb of the greater common good or public purpose. Post 1894, the question of compensation for expropriation was particularly contentious, especially with regard to land reform. The colonial system of collection gave a class of zamindars considerable power over land. It was not clear as to how property would be guaranteed without making any promise on compensation, which would benefit only the deserving owners. This implies that there was a status, no status of right to property as fundamental right in India at that point of time, just before independence. The property was acquired by the government for the public purpose and there was no compensation. Please understand, this is the most important thing. There was no provision for compensation for the acquisition by the government, whether it was just or not. This was the most controversial aspect at that point of time. Now, coming back to the Government of India Act of 1935, which many consider, many scholars and many constitutional experts and practitioners of Indian polity consider to be a precursor or the base from which the Indian Constitution was developed later on. The Government of India Act of 1935 entailed the compensation formula, which the Constituent Assembly decided to retain in the Constitution of India. Now, what happens in the Constituent Assembly? That is very relevant to understand the birth of right to property as a fundamental right. Now, this particular Article 24 of the draft Constitution, it eventually became Article 31 in the Constitution of India. This particular debate took place on two dates, September 10th, 1949 and September 12th, 1949. These were the two dates, particular dates, during which there was extensive debate on the right to property, the issues related to the Government of India Act of 1935, the provisions related to property, and also the provisions related to compensation. And of course, as you can see, the death of right to property took place by the 44th Amendment Act of 1978 as a fundamental right again. The continuous misuse by the government of its power to acquire lands led to the protests acquiring agricultural land, internal displacement, loss of livelihood, and inappropriate compensation. There were many battles between the compulsory land acquisition, compensation, and property rights, which continued till right to property was made a fundamental right. This was before the Constituent Assembly. Please understand that these kind of struggles and battles were on even before the Constituent Assembly met to discuss the framing of the Constitution. Now, what did Article 31 eventually do? It guaranteed that no person shall be deprived of his property save by the authority of law within court. So there is some kind of intervention, a legal intervention and a constitutional protection provided to any individual in protection of the property. This is basically what the provision provides. Now, the post-constitution position. So after 26th January 1950, there were further developments before it was eventually repealed in 1978. We are talking about a 22-year window, a timeline in 22 years, 2 decades. What happened? There were so many battles, so many amendments, so many court battles till the Keshavananda Bharati case, the famed Keshavananda Bharati case, which provides the basic structure of the Constitution, was primarily, also fought over this particular right. So many case laws from 1951 onwards, which were fought over this particular fundamental right. The legislature on its part also kept on fighting with the judiciary by framing ordinances and laws, and the court kept on fighting the legislature by providing for more interpretations and judgments. This battle continued till 1978, and 1978 of course changed the very discussion, the narrative from fundamental right to a constitutional right. Whether after 1978 the debate has rested, no, that we will see in the later part of the lecture. This is the original constitutional position of this particular fundamental right. As we all are aware, there were 7 fundamental rights. Today we only have 6. Now, Article 19, Clause 1 also talks about property, as you can see. And of course, the exclusive fundamental right of Article 31, which specifically relates to right to property. So as you can see, these were the 2 major provisions in the article. Early decisions of the Supreme Court also show that 2 basic conditions were adopted by the courts in the course of several cases. One was public purpose. In the name of public purpose, governments acquiring land. Secondly, compensation. Compensation in regulating the exercise of acquisition under the Constitution. These were the two major areas of debate. And the courts in India, the high courts and the Supreme Court, were faced with two competing rights: the power of the state to acquire a particular property for whatever the reason may be under the disguise of public purpose. Secondly, the individual's fundamental right to property. So these were the two competing paradigms against which the battles went on in the Supreme Court. The Parliament, of course, through the 44th Amendment, gave the final blow to the private property and repealed Article 19, Clause 1, Clause F, Subclause F from Part 3, and also completing the demise and merely inserting a new provision under Article 300A of the Constitution. Now, the next part of the lecture will primarily focus on the legal versus legislative battles, which eventually, which slowly takes us to 1978. So I'll be taking you on a time travel from 1951. See some of the major cases in which this particular right was hotly debated, and some eminent debates. If any of you practitioners, academicians, and students and research scholars are interested, going back 50, 60 years and studying some of the major judgments or major points, you can Google them, you can see them online. Very interesting debates. Later in the lecture, you'll see some slides which showcase the power of arguments by eminent advocates, eminent experts in the hall rooms of the Supreme Court, which eventually changed the course of this country. And the minuscule part, of course, is the right to property. So if anyone is further interested, not only in this particular article, you can venture out and see how the debates shaped, many of the facilities that we are enjoying today. Now, what happened in the courts? Yes, the Constitution, the pre-constitutional position from the Land Acquisition Act of 1894, we can briefly understand the journey of the right to property. Like a story, we come to the most important part, the interval part. In another 10 minutes, we'll all be taking a short break. But before proceeding to the interval junction, these three cases which are on your slide right now, let us just briefly analyze them. The first important case was West Bengal versus Bila Banerjee, 1951, which happened in the Supreme Court. That is third to your right case on the slide. This particular case also is famous for the first amendment of the Constitution. And can you, any guesses? And the amendment took place to Article 31. Articles 31A and Article 31B were inserted in the Constitution by virtue of the first amendment to the Indian Constitution, hardly a year after we became a republic. Only on January 26th, India adopted the Constitution. So another year down the line, there were so many battles, so many issues, and this particular case triggered so many amendments to this particular right. And the Supreme Court argued, after hearing the arguments of the petitioners and the state, they held that compensation, the most important word in property, compensation value to a particular date as opposed to the market value of the land at the time of acquisition was arbitrary. So naturally, when you're purchasing a land, if you're going to pay somebody the actual value of what he purchased 10 years back or 5 years back, that is not called as market value. Market value is what provided right now. Today, we have what is called as guideline value, market value. These are being revised time and again. But 1951, just after the birth of the Constitution, there was not much clarity on the finer aspects of compensation. That is where the first struggle for the right to property took place, and the Supreme Court held that there should be market value. It said that the purchase value cannot be held as compensation. That was the most important takeaway from this particular judgment. Going forward, we have an interesting case which is before the Bila Banerjee case. In 1950, the Kameshwar Singh versus the province of Bihar. Please understand, it was not a state of Bihar at that point of time. The reorganization of Indian states took place much later in 1956. So it was the province of Bihar. In that particular case, there was a very restrictive view taken by the courts on the state's power of compulsory acquisition. And it also talked about protecting the right to property and payment of adequate compensation. Please understand, the word adequate was used in this particular case. That is what kind of set in motion a series of interpretations. And the Supreme Court eventually declared unconstitutional several laws and several legislative actions and policy decisions by the state, keeping in mind Article 14, Article 19, and Article 31. So it was basically interpreting the actions of a particular province of Bihar and terming those as unconstitutional. So that was an interesting interpretation. But the 1951 case relating to right to property is very famous because it led to the first amendment of the Constitution. We will see one more case. State of Bihar again, 1952 versus Maharaja the Raja Sri Sir Kameshwar. In this particular case, the decision of the Supreme Court was that public purpose. It took the view public purpose and compensation when acquisition of land is brought about. So this was a very important case because the contentious judicial interference, interpretations, and the parliamentary interference were the most important debates during those years, those formative years of Indian Constitution in 1950s. The executive, the legislature, and the judiciary kept fighting over each other in interpreting compensation as well as the right to property, because compensation deals with money. That is the most important aspect. Simply fighting over supremacy was not the idea of the three organs of the government. Nobody fights for nothing. The government simply fought over because if you start paying compensation at the market value, the government is going to be at a loss. So they simply found out an idea of escaping this whole clause of compensation by talking about public purpose. Under the guise of public purpose, the government sought to make some laws, make some provisions to escape the compensation clause. That is why the judiciary stepped in, every time to make a course correction. So this was the foundation for the battle. Nobody simply fights, for anything in the court. The parliament simply does not make simple laws. Everybody looks at it from a financial perspective. Economic justice does not come freely. Economic justice, though provided for in the preamble of the Constitution, is not a simple term. It costs a lot, and it costs the treasury a lot. Today, during coronavirus time, for the last week, we saw the new economic package being revealed by the government of India. There are a lot of positives and there are a lot of criticisms for like any announcement. The 20 lakh crore economic stimulus package, or famously known as 2.0, economic stimulus, is hotly debated. Why? Simple: finance, economic justice. You can compare economic justice by what's happening today, as we are all experiencing, with what was happening during 1950s. It is all about finance. Economic justice is equal to financing the economy, providing for economy for all classes of people, which also includes the government. Government also needs some kind of financial flow, to keep its coffers running, to provide for all that it is doing. That was the main reason that the compensation clause was missing, and that is the main reason for the fights that you can see, constant legislative and judicial fights that stemmed in the courts in the early 1950s. The main reason was compensation and the method of acquiring, under public purpose. This was the two major points of focus in the fight, why eventually it became a constitutional right. Now we have, I think, let me stop here. We have another 4 minutes, I think, to the lecture. or shall I continue for another 2 minutes?
Madam, you can continue just 2 minutes, madam.
Okay, sir.
Hmm?
Thank you, sir. Yes, sir. I'll do that.
Otherwise, I will just interrupt, madam. No problem. You continue, please.
Yeah, sure, sir. Sure. Thank you, sir. So we've gone to the next slide. Again, another set of 3 interesting cases, which we will discuss in detail after the break. If you can see the cases, one was Golaknath versus State of Punjab, very famous case law, which we all study under administrative law when it comes to constitution. This case also has a relevant fight with regard to property. Sajjan Singh versus State of Rajasthan, very important case. 1964, the 17th Amendment Act. So this was another important case which eventually discussed the 17th Amendment of the Constitution. See, from 1951, in the Bila Banerjee case, we have jumped to 17 amendments, and many amendments were related to right to property. Shankari Prasad Dio versus Union of India, another important case where the landlords or the previous zamindari system was, again, the zamindars went to court during this particular case, and the 4th amendment was, enacted after this particular case to bring about clarity on 31A and 31B, which we just discussed now. So these are some of the major case laws which we will be discussing. It's a very interesting, but at the same time, a lengthy debate, the right to property. So it's very important to understand the story in entirety to properly have an understanding. Even today, you can write good research papers on this particular right. You can, if anyone is looking for publishing opportunities and looking for ideas, if someone is very deeply interested in Indian polity, even today, you can write good research papers, you can do good research on this particular topic, because it is not only a fundamental right or a constitutional right. The debate is about property. As long as this civilized world exists, this property on debate will continue, and it will provide you a lot of opportunities for all of us. So I think, let me just take a break here.
Your wonderful session morning, and I'm just going to end the first part of the technical session. And as usual, participants are requested to kindly log in with the same user ID and the password. I'm going to end the session.
This particular case was by the zamindars in the court. The challenge was by the landlords or the zamindars under the zamindari system. What was the challenge? The legal challenge was the validity of articles. The 4th Amendment Act, enacted in 1954, to bring clarity on Article 31A and Article 31B, the articles which were included in the Constitution and the fundamental rights, by declaring that the courts should not deal with the question of adequacy of compensation. It is very funny if you read it. So there was a provision, and further, compulsory acquisition of property. What is meant by compulsory acquisition of property, referring to state acquisition only. So the challenge in the court failed, and the validity of the articles was upheld. Now going forward, another important case when we study about right to property is the challenge in the court during the Sajjan Singh versus State of Rajasthan case. What was the challenge? The challenge was against the 17th Amendment Act of 1964. This particular amendment to the Constitution included a special provision. The special provision was regarding compensation. Again, see, the battles are revolving around providing compensation, finance, compensation of land acquired from small farmers. Even now, during coronavirus, the economic package includes a lot of provisions for small farmers, if all of you would have observed, I'm sure. Now, this particular amendment says that the land acquired from small farmers, please note, should not be less than the market value of the land. Very important amendment. Now, this amendment was challenged in the court. Naturally, it all deals with finance. Please understand. So it may be economic justice, but eventually it all hurts the pockets of anyone concerned, whether it is government or private individuals. So the amendment was challenged, but the validity of the 17th Amendment was upheld, and rightfully so. And all these amendments, again, another case, the Golaknath versus the state of Punjab, the First Amendment, the Fourth Amendment, and the 17th Amendment, which we are just seeing, all these were challenged in the Supreme Court. What did the Supreme Court do? It declared the above amendments as invalid. But the important thing is the laws made under these continue to be valid. So the amendments were declared invalid, but the legislative provisions made were valid. This was the judgment of the Supreme Court. The Indian state could not take away the fundamental right by enacting laws, either in exercise of the constituted or legislative power. This was another important provision of the judgment. Now, so finally, where does the story end? Let's go to 1978. Now, the bank nationalization case, famously known as the nationalization case, in the 1960s, specifically 1967, the Supreme Court held that the power of the legislature to determine the amount of compensation as justifiable. It laid down certain principles. This led to the important amendment. We come to 1971, 25th Amendment Act of 1971. The word amount was substituted for compensation. Please note, within quotes, compensation was removed and the word amount was included. And Article 31C was inserted in the Constitution. That is the story of 31A, 31B. Now we are completing it with 31C. This provided that, to give effect to the related DPSP principles, directive principles of state policy also were invoked. 39 Clause B and Clause C shall not be void on the ground that it takes away fundamental rights. This was also an interesting interpretation. The most important case among all these cases was the Keshavananda Bharati case. We are all, I'm sure, aware of the name. We might have studied, used the name. But with regard to right to property, this case is also very important. 1970. The court upheld the validity of all property-related amendments and negated that the status of property right as a basic feature of the Constitution. It was not considered as the basic structure of the Constitution. Nevertheless, the right to receive amount was declared as a fundamental right. Please understand, this was an important distinction that the court is making. And now we go to the 44th Amendment. This put to end all debates once and for all. The Parliament enacted the 44th Amendment, 1978, and it finally pulled the curtains down on two articles, Article 31, which was the fundamental right to property, and Article 19, Clause 1, Subclause F from Part 3. And it was declared as a constitutional right, and Article 300A was inserted in the Constitution. So this is end of story. This particular picture will provide a visual to the Keshavananda Bharati case. Who is Keshavananda Bharati? The one to your right, he is Mr. Keshavananda Bharati. In this particular case, which was heard by a 13-bench Supreme Court bench, 13-judge Supreme Court bench, which is massive, And to your left is Mr. Nani Palkiwala. I'm sure all of us would have heard this name, would have probably read some of his books, and more interested practitioners would have actually read some of his debates. He is Mr. Nani Palkiwala, who saved the democracy. If we can some say, he actually saved Indian democracy at that point of time in this particular case. This particular case also had some provisions related to right to property, as we have already seen. So the brilliant performance of a lawyer in interpreting the constitutional terms has eventually, led us to understand what is known as the basic structure of Indian Constitution. So this is the case. So how has the jurisprudence evolved? I'm going to finish now. The right to property remains fundamental to a human. Yes. Does it remain fundamental to a human? It does. Whether it is a statutory right or a fundamental right, it is a constitutional right. Okay. According to our constitution, today, the current position after all these years, it is a constitutional right. So we are not deprived of the right to property. We do have the right to property, but it is not a basic feature of the Constitution. It is not a fundamental right. This is the second takeaway. Third, any property acquired by the government or the state as a whole needs to be compensated with a just amount. This is the most important provision. After 1978, we do have a lot of battles. Very recently, in the last decade, the Land Acquisition Act, Section 24 of 2013, is highly legislated, highly debated in the courts. Even up to 2019, Justice Arun Mishra delivered an interesting judgment on that. So this is where we stand. So thank you for your time. So we come to the end of the lecture now. So as I said again, going beyond the lectural theme of right to property, anybody who is interested in actually writing about this particular theme, it's a very, very interesting theme to explore. That's why this particular slide, I've put it up. You can see there are so many cases even now. Anybody who is interested in publishing good articles or working on research areas related to Indian polity, specifically right to property, it's a very up and coming area. Lots of research can be done even now. So the history remains the same, but there is still the battle between the executive and the judiciary and the legislature going on even now, as of 2019 also. The Arun Mishra judgment was highly criticized by many. It talks about lapse, providing compensation and the lapse of time. That was the main theme of his judgment. So I hope the lecture was useful for all of you, and let me open it up to sir. Thank you, sir.
Thank you, madam, for a wonderful presentation, and I hope that the participants greatly benefited out of your presentation. And now, as usual, it is time for raising questions with the resource person. And I'm going to request Harshita Bala, and I'm going to unmute Harshita Bala. You can raise your question, madam.
Good morning, ma'am.
Good morning, ma. Good morning.
Ma'am, I had one question that the saving clauses which are related to Article 31A, 31B and 31C, they are only concerned with the private property only, yeah?
No, ma, they are considered with the property as a whole. Definitely. It's a good question that you asked. Yes, please tell me.
Means it includes the public property as well.
Yes, yes, definitely. A government, no, please understand, cannot make a law for a private property. Property is property, whether it is owned by privately or whether it is owned by a company, whether it is owned by an individual or whether it is owned by a quasi-government body. Property is a property. What comes under the Constitution? The Indian Constitution is for all. So it does not differentiate a person, individual or an institution. That is the basic premise that we need to understand.
Thank you, madam. Now I request, thank you. And I request the participants, if you are interested, you can raise your questions. Ma'am, shall I ask a question?
Sure,
No,
sir.
I'm not my question. One participant sent a question in the chat. I think Dr.
Sure,
Tiwari. So why government wanted to acquire property? It is the government property. Why they wanted to buy? Why they wanted to capture property resources? And such way he has raised the question. And the question by Dr. V.P. Tiwari. Why the government will acquire its own property? It is already with the government.
Yes, sir. I think it's a very interesting question. His question will definitely give rise to a lot of knowledge for the participants also who are here today. So as rightly said, government should acquire property or should not acquire property. It's a very hot debate. Even before India became independent, from the Land Acquisition Act of 1894, this is the question that's been bothering all concerned. Now, the reason again is where can the government go for land? If today you want to erect a, let's say what happened in Tamil Nadu, let's take the case of the Coimbatore cluster. Now, how will you replace that particular place? You need land. Thankfully, there was land, a parcel nearby, which was unoccupied. So the government erected a alternate market within 3-4 days. So the Coimbatore land again belongs to the government. It may belong to a particular department of the government. Now, again, we have to come back here. Now, let's say the government today decides they can totally shift to that particular new market and not use the old market. That means land acquisition.